Judgment in the matter of the Crown and Andrews.
Lord Burrows will deliver the judgment in this case.
This is a summary of the Supreme Court's decision in Crown against Andrews, which was handed down during the vacation on the 18th of August. The appeal raises an important issue on the confiscation regime under the Proceeds of Crime Act 2002, which I shall refer to by its popular acronym POCA. The purpose of POCA is to strip away the ill-gotten gains made by criminals. The question raised in this case is, how does POCA work in what is commonly referred to as a CV fraud case, where CV stands for curriculum vitae. A CV fraud is one where a fraudster includes lies on his or her application form for a job and as a result is appointed to the job. On a conviction for fraud, should there be a confiscation order stripping the fraudster of his or her earnings, even if the fraudster has performed the agreed services satisfactorily? In particular, would such a confiscation order be disproportionate under Section 6, subsection 5 of POCA? In 2004, the post of Chief Executive Officer at St Margaret's Hospice, Taunton, was advertised. It was specified in the application pack that as regards qualifications, a first degree was, quote, essential, and an MBA, that's a Masters in Business Administration, was, quote, desirable. In terms of experience, 10 years of management experience with 3 years in a senior position were specified as essential and 5 years in a senior appointment as desirable. In his application form, John Andrews claimed to have obtained a first degree and an MPhil from Bristol University and an MBA from Edinburgh University. He also claimed to be in the course of studying for a PhD in Ethics and Management at Plymouth University. Under the heading of professional qualifications, he claimed to have an advanced diploma in management accounting. None of this was true. He also lied about his management experience. He was interviewed and appointed as CEO at the hospice. It was clear that he would not have been appointed had the truth about his education and job experience been known. In 2006, he told staff that he had obtained the PhD from Plymouth University that he'd been working towards. This was also untrue. He insisted that he should thereafter be referred to as Dr. John Andrews, a title which in due course appeared in, for example, staff structure diagrams and his email footers. He remained in that post for over 10 years until 2015, when the truth began to emerge. During that time, Mr. Andrews did a good job as CEO and was regularly appraised as either strong or outstanding. Using the same or similar lies, he was also appointed to 2 additional remunerated roles as a director and then chair of the Torbay NHS Care Trust and as chair of the Royal Cornwall NHS Hospital Trust. In January 2017, Mr. Andrews pleaded guilty to 1 count of obtaining a pecuniary advantage by deception under Section 16 of the Theft Act 1968 as regards his position at St Margaret's Hospice, and 2 counts of fraud under Section 1 of the Fraud Act 2006 as regards his appointments at, respectively, the Torbay NHS Care Trust and the Royal Cornwall NHS Hospital Trust, and he was sentenced to 2 years imprisonment. Following his conviction, the Crown sought a confiscation order against him. The total benefit Mr. Andrews made from his crimes, that is, his net earnings in the 3 posts, amounted to £602. I'll just repeat that, £643,602. But on these facts, the maximum recoverable amount under POCA based on the assets Mr Andrews had available to use to pay, was only £96,737. The judge at first instance made a confiscation order of that £96,737. But the Court of Appeal overturned that order and held that it would be disproportionate to make any confiscation order in this type of CV fraud case. This was because the defendant, by performing his work in the way he had given good value in return for his earnings. And this was reasoned by the Court of Appeal to be analogous to making restoration of benefits received, so that to strip his net earnings would amount to double recovery and would unacceptably penalise the defendant. The Crown appealed to the Supreme Court against that decision of the Court of Appeal not to award any confiscation order. The Supreme Court unanimously allows the Crown's appeal. The judgment of the Court is given by Lord Hodge and myself, Lord Burrows, with whom Lords Kitchen, Hamblin and Stevens agree. Our central reasoning is that in a CV fraud case, where the performance of the services is not illegal and the defendant may be regarded as having given full value, it would be incorrect to adopt either a take-all approach, as advocated by the Crown, or a take-nothing approach, which was the approach taken by the Court of Appeal. Rather, a middle way is principled and correct. By this, it would be proportionate to confiscate the profit made by the fraudster, comprising the difference between the net earnings that the defendant would otherwise have made and the higher actual net earnings the defendant has made in the particular job acquired by the fraud. The principled middle way does not involve plucking a figure out of the air or a discretionary multifactorial approach. On the contrary, it does require some evidential basis for comparing earnings with and without the CV fraud, and the legal burden of proof is on the prosecution. However, it's important to emphasise that we are not suggesting that a detailed or precise evidential or accounting exercise is needed. That would be inappropriate for confiscation orders, where clear rules and a broad brush approach are necessary so as to avoid complicating the administration of justice in the Crown Courts. In many, and perhaps most, situations of CV fraud, it would be appropriate, as a pragmatic approximation of the relevant profit, simply to take the difference between the fraudster's initial salary in the new job obtained by fraud and the fraudster's salary in his or her prior job. So, applying this middle way to the facts of the present case, one can compare the salary of Mr Andrews in the new job and the salary that he was already earning. He was earning £54,361 gross in 2004 in his prior job, and the higher initial salary he obtained by reason of his fraud was £75,000 gross. The contrast between the two is 38%. On a broad brush basis, a proportionate confiscation order, assuming not exceeding the maximum amount that can be recovered on the POCA, would therefore be 38% of £642,602, which amounts to £244,569. That is the profit he's made from his CV fraud. On the facts of this case, as the maximum amount that can be recovered under POCA, as I've explained earlier, is £96,737, and as that figure does not exceed £244,569, confiscating £96,737 is proportionate. The appeal of the Crown is therefore allowed.
Thank you. The Court will now adjourn.